Thank you, Mr. Chairman, members of the committee. House Bill 2766 would create the Kansas Land and Military Installation Protection Act. The act would prohibit a foreign principal from directly or indirectly owning or acquiring any interest in any real property located within 150 miles of the boundary of any military installation that's located in this state or any adjacent state, except a de minimis interest in such real property. The term real property would not include property used exclusively as a place of residence. Foreign principals would be required to file registration of their property interest with the Attorney General not later than 90 days after July 1, 2024, or the date such interest is acquired, whichever is later. The foreign principal would be required to divest from such registered real property not later than 360 days after July 1, 2024, or the date the interest is acquired, whichever is later. The divestiture time frame would be reduced to 180 days if the foreign principal failed to register such interest. The Attorney General would investigate reports of violations and commence actions in court to enforce the act. Under the new Section 5, no foreign principal could receive any direct benefit related to any economic development program. The Attorney General would be required to prepare and submit reports on any identified non-notified transactions to the Committee on Foreign Investment in the United States. Thank you, Mr. Chairman.
All right, so this bill, does it automatically kick anyone out of the state?
Mr. Chairman, it doesn't forcibly remove individuals from the state.
All right, and so in the case that there is an offender, the AG investigates, and if they don't like that decision, they go to court. Is that the way I understand this?
The AG could file a court action to enforce the provisions of this act. Yes.
Okay, so everybody would get a day in court before there's a decision made.
Possibly, yes.
Okay. Representative Probst.
Thank you, Mr. Chair. But on that line of questioning, if a company was affected and they went to court, what would they be challenging? This is the law that they would be challenging. There's probably nothing in existing statute that maybe a constitutional issue, but I guess I'm trying to understand. There's a remedy for the AG to take somebody to court, but what's the company's recourse if they go to court? Or I guess what area of law are they pursuing?
If there could be a response from the company in court that they perhaps don't fit under a key definition within the statute, there could be a separate action, as you indicated, maybe in federal court to try and strike down the statute under constitutional grounds.
Representative Hsu.
Thank you, Mr. Chair. Kyle, you said when we did the hearing that this applies essentially to all rental or lease agreements, essentially in the state, given the 150-mile radius to anybody who is from a country of concern, who is not yet a citizen or a legal green card holder. But I think that does open up, right, that there are people here who can currently open a business that will not be able to open a business after this, right? There's lots of people here on immigration visas, things like that. And again, you can answer that question, but it just kind of underscores the point. Like, I don't think that we're an appropriate body to try to deal with that sort of issue. People here on legal immigration visas who are not yet green card holders can't open a business now and would not be under this bill.
Kyle.
Representative Hsu, it is correct that if this bill were to pass, that someone who falls under the definition of a foreign principal would not be able to hold or acquire a property interest, whether it's ownership or a leasehold agreement in a business in this state. They could still possibly be part of operating it, but they would not have the property interest.
Representative Croft with a question.
You ready for the
or a
amendment?
comment?
You ready for
We're still on the reviser.
Oh, I didn't have a question.
Okay.
Other than the fact that part of it, just to clarify, we're talking about if they're here on a permanent residency, they do apply. They do.
He's nodding. For the record, he's nodding his head yes. All right. Also, I want to welcome Leader Croft to the committee. He is subbing in for Representative Laura Williams, and also Chairman Rogers. I almost called you Chairman Croft, but Chairman Rogers is here out of respect for the his committee, and he's here because he will be the one carrying the bill on the floor. He does not have voting privileges today, but he will be commenting if needed. Any further questions for the reviser? Seeing none, we'll move on to discussion on Bill HB 2766. Representative Croft.
Thank you, Mr. Chair. And his voting privileges are kicking under the table. I'm just being clarified with that. First off, I want to thank everybody for coming in and talking about all the different topics that are here. I appreciate all the input. Wish we could do everything that was asked. Obviously, we can't do everything. So we tried to make as many people satisfied with the process. And with that, Mr. Chair, I do have an amendment.
Okay, while your amendment's being passed out, do you care to explain it?
Sure. Yes, sir. So again, we heard a lot of we heard opposition testimony from the agriculture, wind industry, and Sonano. And I've, like I said, I've had an open door, gone through, spoken with everybody, as many as I could, that wanted to come in. They spoke even as late as I got text last night going through this process. So I appreciate all that. It does incorporate the changes asked for by the agricultural industry. This amendment allows the companies that have been vetted and cleared by the federal government through the CFIUS process. We heard from the renewable energy that they would like to have leasing provision stripped out, and they would like to have the de minimis interest threshold bumped up to 10% to align with the federal regulations. I just believed, and I told the industry that I believe removing the leasing provision was a little bit too far for me, but I would support the 10%. And so we've done that in this amendment. We also heard some questions about the distance of 150 miles. We did receive that information from members of the Department of Defense, from the National Guard, and from the Army Reserve, our military, the reserves, that the 150 miles was based off the assets we have. We did go back and ask the governor's office for actually we asked the TAG for an official in writing, and we just haven't received that yet. They're going through the process. It's something that takes a while, so I understand that. That's where we go. And they did ask this. We looked at other states. There are many states that do have different mileages. They have different assets, but they also have different things included. So we just chose to go with the large one and be done with it. We could go back and change all that and look at all the different critical components, do different mileages, and do things like that. But we chose not to do that. We also heard from Sonano in their testimony that revealed some concerning facts about their parent company's involvement with the CCP and participation in the government. I do appreciate them coming in and being forthright and talking. I do not feel comfortable basically exempting them from the legislation. And specifically, as they brought in some text, and again, I appreciate the text that was brought in, but it basically opened up the bill. We might as well not do the bill. So I wasn't comfortable with that. It's not so much them as much it is what we don't know about things. I understand if members of the committee feel differently, but that's the way we were in this one. This was another alternative. There was another alternative that was proposed that would have been a blanket exemption for the companies. Like I said, I just couldn't go through that whole point. We must begin to take our national security seriously, and the risk of continuing to allow foreign investors or adversaries to operate in our state is a little too great, and especially as you're starting to hear some of the things that are going on. As far as the amendment that's in front of you, on page, let me see, did you hand me a copy? Is it the same thing? Okay, same thing. Okay, so page 1, the very first thing out there, where it talks about the Fusion Center oversight. One of the things that was asked for in this was a terrorist watch list, a terrorist list to be put in here. The debate was whether we went ahead and just use the federal one. We found that might be an issue with just automatically deferring to theirs. So we gave that to the Fusion Center as for a oversight and to prepare the list and use that as a guide. They can't add any more, but they can reduce from that list from the federal government. Okay, on that one, good. All right, go to the next page, page 2. The first box there, it's the same thing. I mean, it's basically, there's a couple different spots for that where you're going to have to clean that language up and make sure. So this is part of that, just to identify that they're doing that watch list. Then a little bit down is where the 10% versus 5%. And again, I've already addressed that, why they wanted to do that. I think it also gave them more flexibility. It's what matched with the federal government. Argument was a good argument. So I decided to go with that argument, and I feel comfortable with that. It gives flexibility. Page 3, there's a technical amendment in there, and there's a few of these in here where it talked about citizen residents on number 5. The Fusion Center Oversight Board, again, it's that same point again, having the Fusion Center do this. Now, by the way, there was a discussion about, do we do it as the Fusion Center or the Attorney General? We picked the Fusion Center because their assets. If somebody wanted it to be the Attorney General instead, I really indifferent on that part of it, but we picked that portion of it. Page 4 is where we begin the part about the CFIUS engagement, a covered transaction, and the whole thing there for the next, basically, page 4 and 5 covers that component. And at the end of the day, I mean, CFIUS is a massive operation that goes on. It's been in existence for many years, and it's been developed over time. And wanted to give the credit that if you've gone through the process and been cleared by that process. Now, they don't look at everything. They don't look at every lane. I acknowledge that. But other things that you can go through, and if you report in there, then you can, then they'll give you a ruling. It's private, so we don't know that they've done it unless they share it. So that's what they'd have to share with the Attorney General in this process through this, that they have that. And then because of this, then that's where the application would be. The bottom part of that is also about page 5 is about the terrorism. And then, again, the other 2 pages, 6 and 7, are just technical. And what did we have on page 8? Oh, the page 8 was about civil asset forfeiture. It basically applies to felonies. This was not a felony, so we had to make this exception in there for that, so that the civil asset forfeiture process would apply. So with that, Mr. Chair, that's basically my explanation and what we went through in this process. And again, I can't express how much I appreciate everybody being involved and be willing to come in and talk about things and be open about it. So with that.
Okay, thanks. I have one clarification on the CFIUS section. So some companies are reviewed, some companies are not, but can a random company that feels like they may need a review, can they request a review and receive one?
Yes, Mr. Chair. We called them and spent several hours on the phone talking to folks up in DC, and that's what we were told by them, that what we had to go through Congressman's office, and that was what we were told is the process that you can self-apply as well.
Okay, Representative Rajas, Chairman Rajas, the ag community, as far as you know, is on board with this.
Yeah, thank you, Mr. Chairman. Again, thank you for allowing me to be a observer at the table in this discussion. Also, thank you to Leader Croft for having an open door to discuss this. Not to repeat too much, but this started last year with some concerns, and my involvement was to protect agriculture in Kansas. And as it has evolved, as many discussions and many ag partners discussed this and found what we needed, I believe, while you never get exactly everything you want in a bill, this, I believe, is a good start. What this does is, and we had those testify in front of this committee, these companies that have been good corporate citizens close to a military installation that have not been an issue. We wanted to make sure we protected those assets for the benefit they bring to Kansans, especially to those that grow wheat and other commodities and in the pork production business. So, Mr. Chairman, with that, as this amendment is, I believe the agriculture community, at least the chairman of the agriculture committee, will be a strong supporter of this, the way it is written. And I think, again, knowing what we know, but as the leader said, in the last few days, Congress has strengthened CFIUS a bit by adding some more money and adding the ag secretary to that board to look at this. And so I know that's been a frustration by many, that either a delay or not all companies that need to be vetted will be. And so we hope that that's the case. But again, moving forward, I think that's going to be ongoing discussions. But I think right now we want to make sure there were language in there that did not have unintended consequences to hurt good corporate partners and good corporate neighbors here in Kansas. Thank you, Mr. Chairman.
All right, thanks for the clarification and the update. And the motion is seconded by Representative Penn. Further discussion, Representative Clayton, on the amendment.
Thank you, Mr. Chair. Okay, so for the carrier of the amendment, I have a question. At least based upon my rudimentary reading of this, the only company that it appears to affect would be C-Nano. What would happen? So let's say that we kick this bill out with this amendment as is. What happens to that company?
Leader Croft.
Thank you, sir. And appreciate the question. In this process, I'll try to move so I can see. Yeah, no worries. C-Nano is one that we know about right now. That's been this other thing that's going on, is we don't know about others, right? We don't. There's other companies out there that come, and was actually commented in the committee when we had the hearing that there could be other companies that exist. So that's what I'm a little worried. So let's just talk about in general. If you're a company and you fall under this, then you go to the AG. If you have a CFIUS review, then you present that and they do their process and out you go. You're good to go. If you don't have the CFIUS review, then it goes through the AG's process. The AG then makes a determination. And then, as was mentioned, you possibly go to the judicial system with the AG. And if they decide through the process that you definitely violate this law, then you go through the civil asset forfeiture process. Now, the difference is we know about those three companies, right? We know about, as you mentioned, the C-Nano company, because they've basically self-declared, then they would have a 360-day process versus a 180-day process once the decision's made.
All right, so they would have almost a year to go through the process. So the other two companies that, have been, looked at or at least discussed, so that is, Smithfield Foods, and they have been cleared by CFIUS, right?
So that's what we're told. A CFIUS process is a private process, and we don't know that until they declare it. So if we don't even know, C-Nano could have gone through it. Now, I think they did tell us they haven't. I believe that to be true. But if they had, we would not know that. And so until they show that paperwork, right now we're going off the word, and I trust what we've been told.
And then the other one was Syngenta, correct? So, all right, so Smithfield is located where? Smithfield Foods, like in, where in Kansas?
I think they're statewide.
According to my phone a friend, Gary County and Wichita.
All right. And Syngenta is located?
Gary County from my friend.
Okay. Same county. Okay. But C-Nano is in Johnson County.
That's correct.
Okay. Yeah, I still have some misgivings on this, again, just because I have concerns for, if we already have, I know that economic development incentives have been given, and I realize that when you okay incentives, you're doing that at your own risk, but man, I hate doing something that I perceive to be anti-JOCO. Could I convince you to maybe change your mind? Conceptual amendment? It's worth the ask.
So, and again, I've gone through that. The problem is what we don't know, right? And one of the members said, could we look at, I'm sorry, is it okay, Mr. Chair? Okay, thank you.
Thank you, Mr. Chair.
Going through the process, one of the members said, hey, can you look at any other federal agency? And we did that. We spent several hours, again, on that call. What other agencies are out there? What other federal review has gone on? The CFIUS process is the most developed, and it's the only one I could come up with that would have taken all of these different things. You could apply directly to DOD, but DOD is part of the CFIUS process. So again, that's the only thing we had to refer to. There's nothing else right now. And if you can find something else or have some other things, I would be glad to talk about as we go through the process. I was presented that information. I asked that, and I appreciate that from the group representing in that department, not necessarily the company direct, but the language I was provided, and I told them that is that I feel like the language I was given just basically said, if CFIUS decided to not review you, then you're good too. Well, that's kind of like, as I was mentioning earlier, it's kind of like saying, hey, I'd like you to do a review on the Constitution. You go, well, I do insurance. And they go, because you say that doesn't mean that you're cleared. It just means you don't do the Constitution, right? So that's kind of the way this is. Just right now, blanketly, they don't do it. But if they apply, I guess they could apply to that process because there is that self-referral process. So it sounds like they could do something too.
All right, noted. And then just one final question, Mr. Chair. Just so does this amendment, if this amendment goes on, is this still retroactive?
It is.
Okay, thank you.
All right, so I have concern with saying this is an anti-Johnson County bill. This is a bill that has to do with countries of concern owning businesses, no matter where they reside in the state of Kansas. This is a very serious matter, and there are people on this committee and several in the House and Senate that are aware of very severe adverse consequences if we do nothing. Unfortunately, they cannot talk to us about it because it is top secret information. But there are people that will tell you there are very serious adverse consequences if we do nothing. And so it has nothing to do where a company resides. It's who owns the company and what they plan to do with it. Representative Shute.
Thank you, Mr. Chair. Kind of along the same line of questioning relating to the CFIUS process, does CFIUS have to review every application that comes in? If CNano self-reports and self-files, does CFIUS have to take it up?
In the process of going through when they file the application, what we were told was they'll make an initial review in that process. Okay. Again, I don't know if they've applied. That is a secret process. I have no clue if they have. And so if they have, then they can present that to the Attorney General and they can make a determination.
To clarification on the Fusion Oversight Board, I was not familiar with it. I looked it up just now. It's the Attorney General, Adjutant General, and then appointee of the Attorney General. Is that correct?
Research or revisers, you have the answer for them?
I don't have an immediate response. I'd have to double check that statute.
Okay, we'll get back to you on that.
And then one more question. I'm a little bit, I think, confused or concerned about the interaction between the new added language on page 2 for foreign terrorist organizations. I understand that the thinking on why you want to do this, but I am a little confused because you're inserting it under the definition of country of concern. And I can see, one, there being a couple of just kind of statutory language confusions, like, on page 3, there just anytime they talk about country of concern, sometimes it talks about being a citizen of a country of concern. But if that country of concern is a foreign terrorist organization, that doesn't really make sense. And then just more broadly, I think from a broader perspective, I have a little bit of concern because, for example, I mean, just to use an example in recent news, there are several Palestinian organizations that are under the foreign terrorist list, but I think we would want to be careful about putting all of Palestine under a country of concern. So I just have concern about that portion.
Representative Probst.
Thank you, Mr. Chair. Mr. Leader, if you'll indulge me, I'm trying to make sure I understand a couple of things. So on the terrorist list, I'll start there. I want to make sure I understand that we can locally deduct from that list, but we can't add to it. We can't just decide that somebody is a foreign terrorist. Is that right?
That's correct.
Okay, thank you. And then on the CFIUS process, I'm trying to kind of wrap my mind around that. This is, I think you said, is probably the best and most developed system for this review. And but we don't know if a company's applied unless they declare it. And so we don't know, but then there's also another scenario. Sisyphus is not bound by a request to review a company. Like a company could ask for a review. And I think we did cover this, that I'm just trying to set my path. They're not obligated to do a review. Company can request it, but Sisyphus can say, we don't want to do that. What process is outlined in this legislation if there's a company that requests a review and that review is denied, maybe just out of like, for any reason that we don't know, but do we have an alternate process in this legislation to address that?
Leader Croft.
Thank you, Mr. Chair. The process is the AG. That's the process. It's within the scope of this language. What we were told is that, generally they would take it on. As a general rule, they wouldn't, but if you do self-apply, then they would generally take it on. But I can't guarantee that because I didn't get that, and I don't want to misrepresent.
Thank you. So into this process, if Sisyphus is out of the, I don't know if I say that right, but if don't know, we're not going to get in that. If we ask, if that element's out of the process, then the next version, as I see it, is to go to the Attorney General and ask the Attorney General to make a determination.
Thank you, Mr. Chair. That is the process in the bill, right? They go to the Attorney General. Attorney General makes their determination, and then they decide if they want to go to court, and then they have to win in court.
And I want to make and I guess I would like some clarification on this, because the way I read it is not that the company gets to decide to go to court. The way I read it is that the appeal of the Attorney General to the appeal to the Attorney General, there's two things that happen. The Attorney General says you're good to go, and then you're clear. Or the Attorney General says, no, you're in violation of this law, in which case the Attorney General takes the company to court. The company doesn't take the Attorney General to court. The company is like static in this. The Attorney General then says, we're going to take you to court, and we're going to, the state of Kansas is going to take you to court to compel that you divest, that we get some injunctive relief, or that we civilly forfeiture and take the property and make you divest, and that becomes a state asset. Am I understanding this process correctly?
Leader Croft. Or Revisor Hamilton.
I believe that's largely correct, that under the statute, the foreign principal is set on a set path of registering and then divestiture. But if that foreign principal were to essentially not follow those steps and be in violation of Section 3, that's when the Attorney General would step forward and file an action in court to compel following Section 3.
One more. Thank you, Mr. Chair. And then, and it's probably in here, and I haven't been through it all, but do we then follow the same? Oh, so we know what the national criteria is, but if we route it to the Attorney General, have we identified for the Attorney General what process to follow? Are we mirroring something at the federal level? Are we creating something new? Do we feel secure in the guidelines that we've mapped out, or are we giving one person unilateral authority to make decisions about who is a valid owner of property and business in the state of Kansas?
Leader Croft.
I didn't know if you wanted to.
You want to defer to
me to do it,
Revisor?
If you don't want to hear, that's fine. We actually did have a long conversation about, do we create a CFIUS Kansas if you want? The language on that and the development of that for so many years is pretty intense. It's not something we're going to do anytime short. There's a lot of things that we need to look at, and there's a lot of, and as you've already mentioned, actually in earlier, is this really something we should do, right? As far as, I think in this case, it goes to the Attorney General. The Attorney General looks at the law as it relates to this and then makes the determination, and then they defend themselves in court.
Representative Poskin.
Thank you, Mr. Chair. Mr. Leader, under the CFIUS review, so we've got CNano in Johnson County, and we know that they're self-declared and that they have 360 days. Do you know if CFIUS has a determined timeline, a known timeline for review, and is there a cost to that?
Yeah, they do have a determined time. Oh, I'm sorry, Mr. Chair. Okay, thank you. They do have a determined timeline. I think the longest is 90 days. They do have a fee structure that's based off the how much this transaction is. I think the top one I saw was $350,000, but that was a $750 million transaction. So I think, and I'm trying to vote from. Oh, please let me tell you what. I'm going to call a friend. How about that?
Thank you, Mr. Chairman. I'm reading off of a CRS review of that process, their timeline. If it's an informal review, there is no deadline for the committee. But once CFIUS starts a formal review, it goes essentially in 3 steps, and each one has a set time period. So they have a declaration filing with basic information. They have 30 days for that step. Then second, if the risks are not resolved, they go to the national security review. That can go up to 45 days. And then the third step, if risks are still not resolved, they have a national security investigation that can go from 45 to 60 days. And if there are still not resolved risks, that's when they send their determination on those risks to the president. And the president can determine to suspend the transaction or prohibit it. The president has 15 days to make that determination. So under the 360 days.
Right. And just to clarify, CFIUS does not have to take up your application, correct?
Did it say that in there? In that reference right there? I'm sorry, Mr. Chair.
I don't have immediate response to that question.
We'll get that information for you before it runs on the floor.
Thanks.
And I would note that the act it's not in effect now, does not take effect until its publication in the statute book, which would be quite some time. And then they would have, that's when time would start from once they self-report. Any further questions on the amendment? Representative Osmond.
Thank you, Mr. Chair. Just a quick question. We heard about the highest level of CFIUS review, but tell me, what is the process for a mom and pop shop that happens to fall under the parameters of this legislation? What does their review process look like? What does the cost look like?
Leader Croft, can you shine a light on that?
From what I saw on the chart, the lowest is 0, but I can't remember the categories. I mean, it was a pretty significant amount for the transaction fee. Because this is all built around transaction fees, right? So whatever the transaction fee that they're reviewing, then there's this X amount of cost. And I know the lowest was 0. I just don't remember the categories. My apologies. And I can get that to you.
Representative Shoup.
Thank you, Mr. Chair. I think that Representative Osmond was kind of getting at what I also have a question. In this amendment, nor in this bill, there's no case for the state if we do find out that this bill does negatively affect, say, like a recent immigrant who is here legally trying to open up a Chinese restaurant. There's no like adjudication process for them. They can't. Right? There's no like approval of the Attorney General. There's no like the Fusion Center or whatever. They just can't. Right?
Representative Croft.
Thank you, Mr. Chair. The process, as we talked about, the Attorney General makes a determination, goes through the process, looks at it, and then based off that determination, if they feel they go to court, then they can take to court. So they would have a day in court. They would have their due process.
Representative Penn.
Thank you, Mr. Chairman. I seconded this particular amendment, not because I was deeply in love with it. As I spoke with the leader, as he alluded to before, I wanted it to go harder. I wanted it to be a little bit deeper. I wanted it to be something that was necessarily CFIUS K, something with a Kansas twist on it, to ensure our voters that we're doing something to protect our particular state, and we've done our due diligence on it. The leader was very gracious and compromising and accommodating everyone's positions and inputs. So I'm somewhat pleased with what we have here. It does provide that level, I would say, of scrutiny that we need to have going through the CFIUS process. And I would say also that, there's an old cartoon and it had this one quote in it. You may recall it: the absence of evidence does not equal the evidence of absence. So if someone does not self-report or go through the CFIUS process, if they decide to bypass it altogether, it does not mean that they are not a threat. It just means that we don't have the evidence. It means that we are still in the dark. So to allow due process to have its way, to allow the state of Kansas to engage this through the Fusion Center, through the AG's office, to allow folk to actually, stand and deliver if they actually get into the court situation and have that deliberation happen, is something that is a positive. To have the two paths with the incent that if you self-report, it's a much quicker process, or you have more time, I should say, to divest if something is found to foul, versus if someone has to call you out because you're acting like you have something to hide, then that's another issue. The only other thing that I would say, one of the representatives brought up earlier, that if someone comes in, I think it's on page 2, we were talking about the countries of concern and a person from the country of concern. There are not always good actors who come in from countries of concern. I would refer you to that the FBI is currently hunting for an alleged Iranian spy that it believes is involved in plots to kill current and former U.S. government officials. The agency accuses a gentleman by the name of Majid Farhadani, 42 years old, for plotting revenge for the killing of the Iranian general Qasem Soleimani, and that person is on U.S. grounds. Now, if that person wanted to come into Kansas and start a business, we might want to vet them. And I think that that's what this amendment does, so I support it. Thank you, Mr. Chair.
Revisor Hamilton.
Thank you, Mr. Chairman. I just wanted to circle back really fast about the Fusion Center Oversight Board. Yes, it is composed of the Attorney General, the Adjutant General, and then a member who's appointed by the Attorney General with expertise in critical infrastructure protection.
Thanks for the answer. Representative Hsu.
Thank you, Mr. Chair. And this might be a Kyle question to respond to my previous question. In my reading of the bill, I don't see any ability for the Attorney General to okay somebody who is technically in violation but determined not to be a threat. I think I see that they can take in complaints. I see the Attorney General can take action if somebody does not self-report. I don't see the ability in here for the Attorney General or anybody other than CFIUS to be like, this was an unintended consequence. This is okay, but I could be reading that wrong.
I would say the Attorney General's responsibility is to follow this law, period, not to make exceptions to it. But I'll let Revisor Hamilton.
I guess in response, the only situations I could see would be if the Attorney General does his review and for whatever reason does not find them to be in violation of Section 3. The other recourse is in the definition of foreign principal itself for individuals, where they would have to become a permanent lawful resident or a citizen of the United States.
There seem no further questions on the amendment. You can close and go ahead.
Mr. Chair, I close.
All right, so you've heard the motion to amend by Representative Leader Croft and seconded by Representative Penn. All in favor say aye. All against say no. Motion passes. Further discussion on the bill. Are there any other discussion or amendments on the bill? Representative Hsu.
Thank you, Mr. Chair. I have an amendment.
Representative, you want to go ahead and explain your amendment while it's being passed out?
Sure, and I don't think this will necessarily be a surprise to you guys, at least in terms of the intent. First of all, I do want to say I do appreciate the majority leader. I think he has really made a strong effort to listen to my concerns, certainly, and maybe we disagree on this particular point, but I do think that this bill prevents some people who are currently opening up, specifically Chinese restaurants, but any restaurants associated with a country of concern in this state. They are currently opening them. And I think that they will be prevented from opening them in the future. And so I just thought, rather than us dig into all the different types of immigration visas, and if you guys want to read a very long list, look up the types of legal immigration visas that we have in this country. I thought it'd be cleaner just to add in a 3-acre floor to real property, or to the property that this bill applies to.
Supervisor Hamilton, do you have anything to add to that?
I do not, Mr. Chairman. It's a very short amendment.
Okay, so we will need a second on the amendment. Seconded by Representative Probst. Discussion on the amendment. Representative Croft.
And if you have somebody else, I don't mind. My whole point was, at this point, we had this last year where we talked about acreage, we talked about the size. That's not the point of this bill. This bill is about national security. It can happen on an acre. It can happen on 100 acres. So we did this about proximity to military bases, and that's what this thing was about, and critical infrastructure, if you will. But so for me, we thought about this, we had this discussion, and we did not go down this path, and I would actually not support this amendment.
So this would, in a sense, take all businesses out if they were on just less than 3 acres, right? Yep. Representative Probst.
Thank you, Mr. Chair. I do share my colleagues' concerns that some of what we're doing in this is, while I believe well-intentioned and everyone's indicated that there's been, and there has been, good faith effort to negotiate this, I do worry that we are going to inadvertently affect people who are trying to, in essence, build a life for themselves here and do something positive in our state. And I can't help but look at this. I mean, we have this just blanket ban, and I think that, and I don't know if there is, I understand what you're saying, and what I'm hearing is that there's not a land amount threshold that's going to satisfy what you're trying to accomplish in the bill other than zero. Like, it's just zero ownership of a country of concern if there anybody's attached to that country, even loosely. Is that right?
Leader Croft.
Thank you, Mr. Chair. It is tied to all the things we've talked about. Yeah, it's tied to that process. Agreed.
I mean, I'll be supporting this, and I do want to go back to the previous conversation we had and make sure, because I think we're not, unless somebody can convince me that I'm wrong, I'm gonna restate this. There is no mechanism in this legislation for someone to petition their government for the right to have a business in this state under this legislation. There's no recourse for a business. They either self-report, they get reviewed by the federal government, or the AG makes a determination. But in this legislation, I don't see anything that allows me to petition for a redress of a denial of a right to engage in commerce or own property. I think what we have is a process that is top down, that says you either comply with this law or you're in violation of the law. But under these terms, you are not allowed to participate in our economy in Kansas. And if you do, and you don't follow these rules, then you will be found to be in, and we will seize your property and take it and make you divest. I don't see a way for a company from the bottom up to petition for an allowance to practice its profession in this state. If I'm wrong, I'm wrong, but I don't see any evidence of that in this bill.
So when you say there's no avenue for you, you're talking as a citizen of a country of concern, not a citizen of the United States.
As defined in this bill, yes.
Okay.
Which I think is pretty narrowly defined. I mean, I'll give you that.
All right, Representative Croft.
Thank you, Mr. Chair. I was actually going to say, could we just go back and redress that again and say what we're talking about here, so we're clear as to what would apply to?
Supervisor Hamilton.
Thank you, Mr. Chairman. It is true that within the bill itself, I don't see any sort of like administrative procedure system or anything for redress. I think it would be similar to the situation that we heard from conferees, AG Attorney General Kobach, about the current case that's in Florida right now. They passed a similar bill. It's different in a lot of regards, but as soon as it was signed into law, there was a lawsuit filed in federal court by affected immigrants who are trying to finalize real estate transactions in the state. And so that case is still ongoing. So it would be, I think, a similar situation in Kansas, where the redress for an affected individual would be to file a lawsuit.
And Mr. Chair, and the affected individual is somebody that is not here legally, right? That is not, no, it's not here. Can you just address that? Say that part again real quick about who this applies to.
Well, under the definitions of this bill, the affected individual, I mean, they could very well be here in the state of Kansas, in the United States legally, but they would not be a permanent lawful resident. And thus they would be precluded from having a property interest in land in Kansas.
Thank you. That's what I was trying to get to. Thank you, Mr. Chair.
Seeing no further questions, you can close on your amendment.
Thank you, Mr. Chair. And I just want to make the point that the people that I think that this legislation unintentionally affects are the people that are not paying attention to the State House every day. They don't have their lobbyists. They're literally like new immigrants who came probably just to follow family and who are trying to open up a restaurant. And I've talked about this for weeks now. And I genuinely think that there's a relatively large population that is not going to be able to open these restaurants. And so, you know, I know how this is going to go, but I close.
You heard the motion to amend by Representative Shu, seconded by Representative Probst. All in favor, say aye.
Aye.
All against, say no. No. Noes appear to have it. Noes do have it. Motion fails. Any further discussion on the bill? Any further amendments? Representative Clayton.
Thank you. So again, and obviously we cannot predict what will happen in the lesser chamber or on the second floor when it comes to this legislation. But let's say it passes out through both chambers clean, gets signed as is. You know, my concern is just given what is happening with C-Nano and Johnson County, what does that mean? Do they have to get out right away? What are we doing with all of the contractors? I mean, I'm thinking about it from that standpoint, because it's like, I can't help it, right? So just trying to think about these consequences. What does that look like?
Okay, so for those that need an update on what the timeline is, could you rephrase that, or could you go through that one last time? First of all, the bill doesn't go into effect until whatever day, and then once they self-report, go ahead and walk through that process.
Yeah, no, I get it. They would probably have like a year and a half, or thereabouts, right?
Well, asked and answered.
So, okay. I guess we're pretty well decided on this, and I guess that we're doing this, but again, to me, I understand that there is the intent, that it is, circumstantial, that the one company that will be adversely affected happens to be in in the portion of the state that's the highest population. To me, it just sort of smacks of a certain amount of unfairness, and it just leaves a bad taste in my mouth. Now, that might just be my own perception here, but there are opportunities that we could have to fix this. I don't feel like the 150-mile radius thing is necessary. I do feel like that's extreme. I don't usually like to be like Missouri, but in this case, they seem to be fine with a 10-mile radius. So do a lot of other states. I realize that, I have not brought an amendment to do that here in committee because I'm pretty well sure that it's not going to pass. But in the time between, let's kind of let this sit and let's have a think about it. Mr. Leader, I would love it if we could maybe have further discussions between now and when this hits the floor to at least scotch that radius down. I know we can't do it now, but just wanted to put my thoughts out here on the record and have an honest conversation with you in front of all of our colleagues and friends and the entire internet. But thank you for that.
So my guess is there will be several other companies that are out there that we're not aware of that this law may affect. And that's the intent of the law, is to address countries of concern that own companies in the state of Kansas to make sure that we protect ourselves. And it doesn't matter when they were here or when they arrived. If they're here and they're a country of concern and there could be an issue, we need to address it. Representative Croft. I thought you had a statement there.
Oh, no, you actually covered it. So,
okay.
I mean, I could come back and cover some more at the end, but that's fine.
All right. Representative Osmond.
Thank you, Mr. Chair. Can't even pull this forward. There are, I think, I consider probably a number of issues with the bill itself, but I do want to address something that we were talking about just recently. 150-mile radius. 150-mile radius, it basically effectively covers the entirety of the state of Kansas just with a single point of contact. When you have multiple points of contact, you are multiple times over covering the state of Kansas. So why is it that we didn't put in here just an effective ban in the state of Kansas? Why do we even couch it under the terms of a radius of 150 miles when this will, in effect, cover the entire state of Kansas multiple times over? The other part that I wanted to discuss is that we're going with CFIUS as the organization that will oversee the security of an individual's business and make that determination. So we trust them in one regard. They have a definition here under section 802.203 of what close proximity is. This is CFIUS definition that says that it is with respect to military installations or other facilities, extends outward of 1 mile from the boundary of such military installation, facility, or property. So we trust them in one regard to say these are the objectives that we need to uphold, but we're not going with CFIUS's definition in another regard as to what their determination is. It's 1 mile. So I guess the question is this supposed to be a blanket ban, or is this supposed to be a determination of security risk for the United States? Because the federal government has made a determination as to what the appropriate level is for security risk for the United States, and it's 1 mile. So why are we being different?
I'm going to go to Leader Croft here in just a second, but I would say that we could do as other states did and have a smaller radius around a military institution, but then there's also radiuses around all kinds of other infrastructure, and it would still, the bringers of this bill looked at it from every different angle, and it would still encompass most of the state of Kansas. And this just made it easier to figure out for companies where they reside and how to do the math and what qualifies and what doesn't, rather than identify every single thing in the state of Kansas that might be critical infrastructure. And I'm sure that Leader Croft has a lot more to say about that and why the military and state installations ask for such a wide radius. Thank you.
Thank you, Mr. Chair. And you are right on. That's exactly as we went through this thing, looking at all the different critical infrastructure, and we could list it all. If you go through and put 10 miles on some, 50 miles on others, and go through this process, it will end up still being the whole state. There was a recommendation that was made this way. We looked at it from all the different angles. This was the easiest to understand and go through the process so everybody know where they fit in the thing. As far as you referenced the CFIUS distances, that is true. They do have a 1 mile. They also have 100 mile, and they have another mileage that they don't talk about. So they have a list of all different kind of miles in there. We took the 150 miles from our military installations, from our Department of Defense leaders in this state, referenced the assets in the state, as I mentioned earlier. So that's why we went there. It wasn't one that I picked early. It's one that they recommended, and that's what we went with. So that's where we are, and that's how we got to that point.
Any further discussion on the bill? Seeing none. Committee, I would direct your opinion or your attention to Senate Bill 172 for the purposes of working this bill, and I will call on Leader Croft for a motion.
Thank you, Mr. Chair. In this, I'm going to make a motion or making a motion to remove the contents of Senate Bill 172 and insert the contents of House Bill 2766 as amended and pass out favorably.
Motion is seconded by Representative Penn. Any further discussion on the bill? Representative Sutton.
Thank you, Mr. Chair. Does that mean that we're not increasing the CAPERS lump sum death benefit?
That was removed, yes.
Thank you, Mr. Chair.
Seeing no further discussion, Representative, Leader, you may close.
Thank you, Mr. Chair. I close.
Okay, committee, you've heard the motion to pass Senate Bill 172 favorably as amended.
I guess I should have said all that.
You did. Is that the right way to say this?
No.
Okay, so we're gonna vote on moving the contents into the bill and removing the contents of the bill. Not necessarily in that order.
So I shouldn't do the pass out favorably. So I'll renew my motion to say my motion is to remove the contents of Senate Bill 172 and insert the contents of House Bill 2766 as amended.
Okay.
Is it a substitute?
No. Okay. All right. Doesn't need to be part of the motion. All right. So all in favor, say aye.
Aye.
All against, say no. Motion passes. Now with a motion to pass out Senate Bill 172.
So, Mr. Chair, I make a motion to pass out House substitute for Senate Bill 172. Favorably for passage.
Seconded by Representative Penn. Committee, all in favor, say aye.
Aye.
All against, say no. Motion passes. We go down the next one.
Yeah, you want to do the next one? Yeah, go ahead.
Representative Clayton with a question.
Thank you, Mr. Chair. Okay, so just to clarify, regardless of our support of this or not, so this is now House Sub SB 172?
Correct.
Thank you.
Do you want to move forward with the
Yeah,
other
let's
one?
go ahead with the drone.
You've got confirmation back?
Yes, sir.
Okay. What bill is that? We're going to open discussion on House Bill 2820, and that is the drone bill. And we'll get an explanation on what the bill does from Revisor Hamilton.
Thank you, Mr. Chairman. House Bill 2820 states that a governmental agency shall not purchase, acquire, or otherwise use any drone or any related services or equipment, the critical components of which were produced in any country of concern or produced or owned by any foreign principal. Such drone components, services, or equipment acquired before July 1, 2024 could still be used by a governmental agency until July 1, 2029. If the agency determines a component needs to be replaced, it could use a replacement component acquired before or prior to July 1, 2024, but no new replacement component could be acquired from a foreign principal. Agencies could complete an otherwise prohibited acquisition under certain circumstances. Thank you, Mr. Chairman.
Any question on what the bill does? Seeing none, discussion on the bill. Representative Croft.
Thank you, Mr. Chair. I do have two amendments. One is conceptual. If you want to put them together, it's up to you. But the first one is about, we heard discussion the other day. Do you have the amendment? We want to pass that out. We heard discussion about the drones replacement, have a fund set up. So with that, Mr. Chair, I have an amendment for adding that into this bill.
Revisor Hamilton, you want to walk through that?
Thank you, Mr. Chairman. On page, well, I'll give people just a moment to get their copies before I start. All right, so starting on page 1, line 32, the amendment would prohibit governmental agencies from selling or discarding any critical component. Prior to July 1, 2029, they would have to transfer such critical components to the Wichita State University or to Kansas State University for research and refurbishing for future use. Upon transferring all such critical components, the agency could submit a request for reimbursement to the Attorney General for the costs of purchasing new drones of like kind and quality to the transferred drones. If you turn to the second page of the amendment, the new language would be added. The Kansas Drone Rehabilitation Fund would be established and would be administered by the Attorney General. It would be used to fund that research and refurbishing of drones by Wichita State University and Kansas State University, and again to cover reimbursement costs for governmental agencies. On July 1, 2024, or as soon thereafter as monies are available, $2,500,000 would be transferred from the State General Fund to the Kansas Drone Rehabilitation Fund. Thank you, Mr. Chairman.
The amendment is seconded by Representative Penn. Any discussion on the amendment? Representative Christy Williams.
Thank you, Mr. Chair. So the $2.5 million would then, the intent would be just to replace those that they are getting rid of. And so therefore it'd be a one-time fund. We wouldn't be doing this in a cycle, correct?
Yes. So the way it's structured is it's a fund that's set up, and hopefully the way it would work is that some law enforcement agencies will submit their drones for reimbursement. Those drones would be researched by the universities to find out how they work and what they're doing and how to fix them so they can't do that. Then those drones would be then sent back to other law enforcement agencies, and so it would be more or less an evergreen type fund.
So would that mean that it's a first come, first served basis if we have 200 plus agencies and however many number of drones? It's going to be whoever makes the request first, or is this going to be prorated by agency?
It's going to be run by the Attorney General's office, and they'll make the rules and regulations on it and how it's going to work. Also, I believe these agencies have 5 years to do this. Is that correct?
That's correct, Mr. Chair.
Okay, so basically this will not be a fund that the legislature has to continue to fund.
There may be in the future more funds requested for it, because if you do the math on a $50,000 drone and there's several hundred of them, it could get expensive. But if you recall the conversations, these do depreciate. They have a 5-year shelf life, and so when they trade them in, they'll be depreciated, and then they'll pay for like kind of quality at a depreciated rate. then once the drones are revamped and refurbished, they'll sell them back to the future and kind of swap them out. That way we'll have an evergreen fund. It's quite genius, actually. Good job, Mr. Leader. Representative Sutton.
Well, I was certainly going to say genius somewhere in my words. Thank you, Mr. Chair. No, I'm trying to recall, and I'm having a moment of not genius here. We have a fund, and I think it's in the Highway Patrol. I think, and I'm looking for it in my head, and I haven't found it yet. That is for replacing equipment, even for the locals. And I'm trying to find it in my head. Wouldn't we utilize that fund for this rather than creating a new one?
So originally we looked at that. There is a fund in the AG's office that is structured for law enforcement equipment for counties. And so we didn't want to confuse that fund currently has $200,000 in it. And we didn't want to eat into that because it's things like bulletproof vests and replacement of that kind of thing. And we didn't want to obstruct that from happening.
Okay. And did we think about the Highway Patrol Aircraft Fund?
No, but we sure could buy a lot of drones instead of a helicopter.
9.7 mil is sitting in that one this year.
No, that wasn't, to answer your question, it wasn't discussed.
Okay. All right. Thank you.
Representative Probst.
Thank you. Well, I'm not going to protest too loudly, but I would be remiss if I didn't have at least a little conversation with my friends in this committee about the number of times we've had conversations about creating new funds, about growing government, about, mandates that then we have to fund. And it is interesting to me to see which unfunded mandates we don't fund and which unfunded mandates we do fund. This fund will be around for a very long time. We will put money into it. There's no sunset on this. So we'll be putting money into this for a very long time. And I anticipate that as technology grows and improves and the use of drones becomes more normalized and more expansive in the state, we'll be spending more money. And it's an interesting dynamic where we have an issue that we've decided to elevate this year, and an issue that I've been on record saying I'm not sure we're actually qualified to address, because I'm not sure that at the state level most of us have the intelligence experience to fully understand. And here we are creating a new fund to address an issue that we are raising this year, and I just feel like it's important to point that out. I just think we're creating a new obligation that's going to last for a very long time, and we're going to do it eagerly, much more eagerly than we fund other things in the state. So, thank you.
I would tend to agree with that, with the exception that this bill only addresses the drones that are here that have issues, and they're precluded from buying new ones. This would only be for the drones that are currently here and that are out there, and as we replace them, there will be no further need. It's not like we're establishing a drone to purchase equipment. We're not making the law enforcement purchase new drones outside of the ones that we have concerns with. We're just trying to replace the ones we have concern with. And as we heard yesterday, they're very expensive, and it would be very difficult for some local law enforcement to budget for them. And that's why we decided to do this. Representative Penn.
And Mr. Chairman, that was the point that I was going to make as well. That's why I seconded the particular motion. I would see that we would have a certain drone population lifecycle management of those that have issues, different types of tech that we're trying to, ferret out. And after that has been turned over, ameliorated at some point in time, also with the prohibition that you continue to buy new drones that have the same issues, right? At some point in time, you're going to actually finish that entire batch as they do it and turn it in, refurb and push it back out. So I would see that this would be somewhat finite at some point in the future.
Representative Dodson.
Yeah,
Thanks, Mr. Chair. Just real quick, I think if we didn't have this bill, there'd be a natural attrition anyway. So that each law enforcement agency, probably through the county, would submit a bill if they had a need for another drone. So when you put this bill in place, then the thing that happens is, as the head of the Sheriff's Association told us the other day, is the difference between the cost of the drones they're currently getting, arguably the DJIs, and an American drone that costs more money. So attrition will take care of most of this down at the local level. And then a lot of these funds will be, I think, used for buying a drone that obviously costs more today, but may not cost more in the future.
Representative Chrissy Williams.
Thank you, Mr. Chair. So just back to Wichita State and K-State again. So then are they acquiring this property and they are then responsible? They are the new owners. They can then, remake it, sell it. And I know you said that the AG has the authority to make rules and regs, but there's a lot of moving parts here. And I'm not sure if that fits wholly with everything we're doing.
Right. So the intent, I don't think it made it into the amendment, but the intent was for them to study them, find out what they're doing, fix them so they can't do that, and then sell them back to law enforcement here in Kansas on a trade-in basis as others trade theirs in at a reduced cost.
I think that at least in the final form, we should be a little more explicit so that it's clear to them, for somebody that wasn't here for this conversation. And the representative to my left here also made the point that it should have a sunset. So once we get this finalized, and then it should move back to local responsibility, because I do think technology does it. The price goes down over time. And once we have the technology, so I just would hate to see the ongoing fund without a sunset, and then also putting the explicit details in here, or at least some of the explicit details of the intent. And perhaps we could just give the reviser the latitude to update that. Thank you.
Revisers aren't comfortable with that, but we will address it when the bill gets to the floor. We'll clarify the language. Representative Hoffman.
Yeah, thank you, Mr. Chairman. I do think there should be a sunset and on the fund. So just July 1st of 2029 sunset. So that would be a motion.
That's a substitute motion.
Yeah, I guess I'd have to make a substitute motion for all the rest, but just add the sunset of 2029.
You can make a substitute motion to add the same language with the sunset. So the motion is to add the same language, except for with the sunset.
Yes.
Seconded by Representative Croft. Any questions from the reviser?
One quick thing I was wondering about, and I never jump into the policy discussions or anything, but more of a logistical thing, is that the way that the amendment is crafted, these agencies have until July 1, 2029 to transfer their critical components to the universities. And then after that point, once they've made that transfer, that's when that they can go to the AG for reimbursement. So I just don't know if you would run into trouble if someone was getting really close to that deadline, the statute lapsed, maybe the fund went away. Could they still get that reimbursement from the AG, or would you want to push that sunset maybe to the end of the calendar year?
Or to 30.
Representative Hoffman.
So is the thought that it's going to be 2.5 million every year after, or it's just going to be 2.5 million now? It's not going to be added to. Is that specifically in there where no more money will be added to it?
Well, my only response to that is just that, you know, every year you never know what the budget committees are going to be up to. But that is not laid out here in this amendment, that it would be an ongoing expense each fiscal year. But what I've been referring to is just the overall deadline of July 1, 2029 for them to transfer all those critical components, and that's the time that they can no longer use those components either. So I just wasn't sure if you wanted to lapse the entire statute, the entire bill on that same date.
Well, no, I wouldn't want to lapse the entire bill because I don't want them to be able to go back and buy drones from.
So is the sunset just limited to the funding?
Yes, just
to the fund itself.
Yes, just the
Okay,
fund itself.
I see. Okay, thank you.
Yeah. Does that make?
Woo, thanks for clearing that up.
Yeah. Yeah, I don't want the whole thing. Yeah.
Any further? Do you have any other clarifying questions? Okay. Representative Dodson.
Could he just restate the amendment?
Representative Hoffman.
Yeah, thank you, Mr. Chairman. It would keep the existing language, but it would sunset the fund in January 1st of 2029.
January 1st
or July 1st. I'm sorry, July 1st, 2029.
Any further discussion on that amendment? Yeah, seeing none, Representative Hoffman, you may close.
I close.
The committee heard the amendment offered, or substitute amendment offered by Representative Hoffman, seconded by Representative Croft. All in favor say aye.
Aye.
All against say no. Motion passes. Representative Croft.
Thank you, Mr. Chair. And so I have the conceptual part of this amendment now, which is in the definition of drone. So if you actually had the bill, it would be on page 2. But the drone is defined as means an unmanned aircraft, watercraft, or ground vehicle, or a robotic device that is controlled remotely by a human operator. And then it goes on and on. The motion I'm making is I'd like to remove the watercraft or ground vehicle or robot device. And I simply want to focus on the air portion right now because the ground portion gets a little complicated and we wanted to make sure we get it right. So I'm recommending we remove that language so it would read now, drone means an unmanned aircraft that is controlled remotely by a human operator or operates autonomously through the computer software or other programming.
Revisor Hamilton, do you understand what he's trying to do?
Yes, Mr. Chairman.
Okay. Are there any questions on the amendment?
Yeah, just a point of clarification just regarding the motion. So we voted yes on Representative Hoffman's substitute motion to alter the Croft amendment. Is this conceptual one that you are making a conceptual substitute motion to your own amendment or to the bill? Because if that's the case, shouldn't we vote on Hoffman's substitute motion to alter the Croft amendment, then vote on the Croft amendment, then go to Croft's substitute motion or other motion? I'm trying to keep it all straight.
All right, so
thank you.
We just voted on Hoffman's, Representative Hoffman's substitute motion, which kills the initial motion. Okay. And so there's nothing else to do on that. This is a new motion from Representative Croft on a new amendment.
Okay, thank you. Appreciate that.
Seconded by Representative Penn. And Representative Penn have a statement. Question.
Yes, Mr. Chairman, thank you. I wanted to ask the carrier of the conceptual amendment, is there any threat from ground or water vehicles at the same peril as the air vehicles?
Thank you, Mr. Chair. In talking to most of the folks, some of these vehicles that we're talking about removing are built in foreign countries, Canada, we heard some other places. But right now, because the location and we wanted to make sure we get the language right, how much visible space they get the map and other things, there was less of a threat for these right now. And so we wanted to go back, focus on the major threat, and then we'll come back and address these as we make sure we get the language right. And remember, as I talked about this, I don't like doing this, but in these cases, as we keep going, if we find changes, I've given the chair a commitment that I will stand on tables if I have to, not dance, but stand on tables and get these things right if I need to.
Very well, Mr. Chairman. I learned a long time ago, slow is smooth and smooth is fast. I support this. Thank you.
You're coming up with all kinds of new statements today, Representative. Any further discussion on the Croft Amendment? Seeing none, you may close.
I close.
Committee heard the motion to amend, seconded by Representative Penn. All in favor, say aye. All against, say no. Motion passes. Any further discussion on this bill? Representative Osmond.
Thank you, Mr. Chair. So, unlike the previous bill that we had, I don't see any major issue that I'm concerned with here. But there is a minor issue that I at least want to bring up. We have, under this definition, we have countries of concern. And I don't understand under the previous bill or under this bill why we just didn't go with an outside source, that the U.S. State Department, as the determination of what country of concern is. I understand we had discussions on it. My larger question is this, though. We now have, if this were to pass and both of them were to become law, we would have a new definition, a new phrase, countries of concern, that has two different definitions under two different statutes. Because as it's defined, one lists countries and one lists countries and terrorist organizations. So I just wanted to at least point that out. We've created a new phrase. We're defining it differently under two different statutes.
Representative Croft, you want to add the terrorist organizations to this? Actually, these are just drones that are made by the same definition that's in the other deal, right? Okay.
Right.
Yeah.
Right.
Okay.
It's an interesting discussion, but I don't think the terror organizations right now are making drones that we're buying from.
All right. Seeing no further discussion on the bill. I draw your attention to Senate Bill 271, and with a motion, Representative Croft.
Thank you, Mr. Chair. On this bill, you said it was 271, correct? I move that I have a motion to remove the contents of Senate Bill 271 and replace it with the contents of House Bill 2820 as amended.
Seconded by Representative Penn. Any discussion? Seeing none, may close.
Thank you, Mr. Chair. I move that we pass out House Substitute.
You got to vote on that first.
Okay, sorry.
So you close?
I close.
All right. All in favor, say aye. All against, say no. Motion passes. Representative Croft with the motion to pass out Senate Bill 271 favorably.
I move that we pass out House Substitute for Senate Bill 271 favorably.
Seconded by Representative Penn. Seeing no discussion, all in favor say aye. All against say no. Motion passes. I'd like to thank our special guest for joining us today. Representative Croft, do you have a statement?
Yeah, Mr. Chair, thank you very much. And as I've always committed to you, if you have ideas, and I thought that was a great point, I'll be glad to look at them as we go through it. Recognize, especially on this drone, when we went a little fast, want to make sure we get the points that were made. Please, the door's open. Come talk to me. I know my chief's probably not very happy with this comment, but I'm open. I will still have the discussions with you. I want to learn and would enjoy the conversation. So, Mr. Chair, again, thank you for this committee and all the hard work and allowing us to go the way we did. Thank you, sir.
All right, committee, we're back to daycare tomorrow. So not that came out wrong. I'll see you tomorrow. We're adjourned.